Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Steve Barnes. In this episode, we'll be looking at the current state of U.S. surveillance law. We'll examine what the future holds with the recent passage of the USA Freedom Act and whether and how balance can be struck in America between national security, transparency, and civil liberties. Joining us today to discuss these issues, first we have Jeffrey Vagle. He's a lecturer here at Penn Law and the Executive Director of Penn Law's Center for Technology, Innovation, and Competition. Also joining us from Michigan is Marcy Wheeler, an independent journalist who writes on national security and civil liberties. She blogs in depth on these issues on her site, emptywheel.net. So let's begin. Jeff, we'll start with you. What are the bases for U.S. surveillance law today?
Well, it's a hodgepodge of laws that regulate surveillance from all the way from municipalities all the way up to national security. But when people think about surveillance today, they're probably thinking about one of three legal regimes. The first is, in no particular order, the first is the Patriot Act. The most famous section of this is Section 215, which was in the news recently. It's a very large act. Section 215 is just one small part of that. We also have the Foreign Intelligence Surveillance Act as amended in 2008. Foreign Intelligence Surveillance Act came out of recommendations from the Church Committee in the 70s, which was in response to surveillance abuses in the 60s and 70s. And it has since been amended many times. The most recent amendment of 2008 is what we're currently looking at. Section 702 of that act is probably what people are thinking of again in terms of national security surveillance. And then lurking in the background is Executive Order 12333. This is a 1981 executive order from the Reagan administration. And it is, not many people know exactly the scope of this executive order. Article 2 powers of in the Constitution grant the president the power to enforce the laws and make the executive branch work, in effect. And so executive orders fall under that. They do have force of law. They also can be challenged in courts, although Executive Order 12333 has not been seriously challenged in courts yet. That's trying to challenge national surveillance law is tricky in courts. And the interpretation of Executive Order 12333 is of some concern. It's a very broad executive order having to do with intelligence gathering for national security purposes. But as we've seen with Section 215, we have secret interpretations, in effect, of these laws. And so Executive Order 12333 is probably the broadest of those three legal regimes that I just discussed with respect to how much power does it grant U.S. agencies to conduct surveillance within the United States.
Mm-hmm. Marcy, do you want to add anything to that?
Just to give an idea of scope, the Section 215, which is what authorizes the phone dragnet, and as Jeff said, it's been much in the news. About a year ago, Richard Clarke, who was just coming off serving on the President's Review Group for NSA activities, he said that 215 is a mere fraction of the data that gets collected, and the rest is EO 12333. So when we talk about these authorities, what we know is the giant program that is the phone dragnet program collecting the phone records of every American is actually just a tiny bit compared to the EO 12333, which Jeff just walked you through.
Right. Do you have any inkling of what 12333 encompasses? Like what kind of practices or intelligence is collected?
Well, herein lies the problem, right? We have national security does require some amount of secrecy with respect to how certain agencies do their job. That's understandable. The problem that arises, and this falls under this balancing act that we have to maintain between civil liberties and national security and safety, is that the government, whenever the government secretly interprets law, we don't have the natural adversarial process that our lawmaking usually has. For example, the FISA court, the court system that was set up as part of the Foreign Intelligence Surveillance Act, is a secret court. It's not an adversarial court. It is an Article III court. It does have Article III judges that sit on this court, but it's not adversarial. And by that I mean there's no second party. There's only one party, and that's the government, making an argument to a judge in secret with no one representing the other side to act as a force against the government. And that's, if anybody, anybody familiar with the U.S. court system, it's a system based entirely on this adversarial system. Unlike other nations, civil court or civil law nations, which where the judge is actually driving the investigation. Here we don't have that. The judge is a third party that's just watching this argument going back and forth between two parties, and that's worked pretty well. It breaks down when you remove one of those parties and you only have one party making that argument.
One easy way to think about it is EO 12333 authorizes everything that happens overseas. We know that it does authorize some things inside the United States. That's what Bush did, his Stellar Wind program, which has entirely moved to FISA, but it was this dragnet surveillance program up until 2004, 2007 range. But what's interesting about it is that PCLOB, which is the Privacy and Civil Liberties Oversight Board, is looking into a couple of the 12333 programs to consider their privacy implications for Americans. And it has two in mind. We don't know what those two are, but one of them apparently also may involve collection within the United States. So everything outside of the country, with very narrow exceptions, would be 12333. And we know, for example, NSA does a lot of bulk collection. It would also include covert activities. So things like hacking, Stuxnet would have been done under 12333 probably. But there are, as Jeff said, one of the tricks is that even with that easy breakdown, overseas 12333, domestic is FISA, there's still little cracks where 12333 authorizes stuff in the United States.
Mm-hmm. Well, thank you, Marcia. That was great. So for the purposes of our discussion here, it seems like for many Americans, the concern is with the bulk collection programs targeting American citizens doing nothing illegal, just their emails or phone calls or Skype sessions get swept up in the NSA's programs. So the USA Freedom Act passed June 2nd. How does it update existing law, and what in your analyses are the strengths and weaknesses of USA Freedom?
To address the first implied question that you had, one of why Americans find this mass dragnet surveillance anathema is because it really does go against some of the founding principles behind the reasoning behind the Fourth Amendment. The Fourth Amendment of the Constitution it protects our persons, homes, papers, and effects from unreasonable search and seizure. There's a large body of law on the Fourth Amendment, and one of the founding principles behind the Fourth Amendment was this idea that the founders found general warrants that were essentially fishing expeditions by the British government at the time to be just completely unacceptable in their society. And so what the Fourth Amendment does is it requires a particularized suspicion that is based on probable cause, sworn before a judge, that sort of thing. It does require a number of steps to obtain that warrant, and only then can the government come in and search the person, home, papers, and effects. What these mass surveillance programs really are general warrant-like programs. They are gathering data, metadata, and again, for those that say, well, it's just metadata, there's a whole line of arguments about why metadata is important. But it's this mass dragnet that is really just a fishing expedition. For the intelligence community has said, look, in order for us to find the needle, we need the entire haystack. That metaphor, Bruce Schneier has recently criticized that metaphor, but metaphors aside, we have to ask ourselves that under our system of laws, do we allow that sort of haystack gathering by government agencies of U.S. citizens? Now, the USA Freedom Act was something of a response to this issue. Marcy, correct me if I'm wrong, I believe it's the second version of the act. There was a first one that came out in, well, second big version, major version. First one is, I think, 2013 it was originally drafted. This one, the version that just passed is in some eyes weaker than the first one. But it does have a couple of provisions that are very important, one of which is this notion of having amici or an amicus, a friend of the court, present at the in FISA court proceedings, meaning that it will be something closer to, I'm not sure it will be an actual adversarial process, but there will be someone there representing the people, in effect, to push back against some of these government arguments. And I mean, Marcy, I'd be interested, what do you think about the efficacy of this amicus provision as part of the FISA court in the Freedom Act?
I mean, it's a great first step and a necessary first step, but one of the problems with it is that the executive branch is still allowed to claim any kind of privileges. And so, for example, when Yahoo challenged in 2007 the Protect America Act, which was the predecessor to FISA Amendments Act, when they challenged it, they worked with Mark Zwillinger, who was cleared, top secret clearance. Yet most of the documents in question about what they were doing and what the government was asking Yahoo to do, and importantly, where that data would go once it came into the federal government and how it might be used against Americans, that was all privileged ORCON, originator controlled, which meant that the NSA, whoever else originated the document, could say, well, I don't want Yahoo to be able to see that, which they weren't able to. And so Yahoo was ultimately arguing in the dark, and there's very little to prevent that from happening going forward. Because, you know, the government can still claim ORCON, can still claim executive privilege. The FISA court now gets to decide whether any information is relevant, but is not required to turn over all relevant information. And so this is what we've seen in the past, specifically with the Yahoo case, but not just with the Yahoo case, where the advocate is still arguing in the dark. But I liken it to PCLOB, which I mentioned earlier, the Privacy and Civil Liberties Oversight Board, which was first instituted in 2004 as really an executive branch driven entity. And then by 2006, 2007, Lanny Davis, who was the Democratic appointee on it, quit. And he said, I can't do my job because I'm not being given information I need to. And ultimately, in 2013, PCLOB finally became functional. And I think that's what this amicus position is going to do, is it's going to start a process, and 9 years down the road, we might see something that does what we need to do. But I don't think it's all the way there yet, precisely because the executive branch gets to decide how much information they want to share. Same thing is true. One of the other provisions is that any significant FISA court decision is supposed to be declassified, but the Attorney General and Director of National Intelligence can say it's too sensitive. In that case, they come up with a summary of what the decision was, but we have a sense from FOIA's for these same decisions what those summaries are going to look like, and they're not all that helpful to explain what the underlying law is. So again, these are important first steps. There's nothing wrong with them, but we need to be realistic about the fact that the executive branch is really still able to decide whether they want to participate in this or not.
There's another feature that I think was on the wish list for some that wanted a stronger USA Freedom Act, and that was strengthening the minimization procedures that currently exist under FISA. So minimization procedures are required by law so that if the government agency, while collecting data, inadvertently collects data that they shouldn't have, meaning it was in violation of Fourth Amendment or is any number of reasons. But if they shouldn't have that data, and it was only inadvertent that they collected this data, they need to minimize these mistakes by getting rid of that data, culling the bad data out and only keeping the truly relevant data. There are some rather large loopholes in the current minimization procedures, one of which is the fact that any information that's encrypted is automatically kept and stored by the NSA and other government agencies. And that means that, and that's regardless of where the information came from. So if you and I have an encrypted conversation online, those data could be kept and not minimized under our current law, the current interpretation of the law. That's problematic. I mean, I guess most people would say, well, I don't encrypt. When was the last time I encrypted anything? Well, I mean, if you're using a web page with your bank, for example, the little lock icon that shows up on your browser means that the packets that are being sent back and forth between you and your bank are encrypted for good reason. I mean, there's a reason why we don't want these data just out there in the clear. We've seen what happens when data are out in the clear. So that means that as our communications become encrypted more and more, even our the sort of tacit communications or communications where we're not explicitly encrypting, those data could potentially be kept and held for an indefinite period of time under the minimization procedures, which, I think that's problematic. It is basically a large loophole around some of the reasoning behind these minimization procedures.
Right. Marcy, anything to add to that?
Well, let me take a step back and explain the rest of USA Freedom Act just so that it's out there. Is that the key provision to it was an effort to limit what was called bulk data. And to understand the law now, you need to understand how the intelligence community defines bulk, which is all. So anything without a discriminator. So when they collect all of the phone records in the United States, they do that by going to Verizon and saying all, going to AT&T and saying all. And so what USA Freedom Act tried to do, both for Section 215, for FISA pen registers, and for NSLs, was to say we're going to make it so you can't collect bulk data anymore. But the way they did that wasn't the first version of USA Freedom Act tried to say everything's got to be really directly relevant. You can't get information on somebody who doesn't have any tie to your suspect. In this case, it still allows bulky collection because what it says is you need to use a specific selection term, therefore a discriminator, to choose the data you're getting. So you can still get, for example, pressure cookers purchased using Visa, which is an application that they could very well, it's been speculated, we know they've gotten pressure cooker and other precursor information using Section 215, and so they wouldn't be getting all Visa records, they'd just be getting pressure cooker purchase records, but you can see that would be still tens of thousands of Americans who have no interest in making a bomb out of their pressure cooker. Another example is if you use a stingray and target, say, my phone number, you're going to collect thousands and maybe hundreds of thousands of other Americans along with the data that you're using to collect me, and NSA may well keep that to find out who else is in my vicinity. So the basic function of USA Freedom Act is to impose some upper limit on the kinds of collections that NSA and FBI, because much of this is done by FBI, can do. But it's not as strong as a means to do so, and we should expect the NSA and FBI to continue to get these bulky collections. So that's another basic thing about USA Freedom Act. But one really important detail about it, though, is I talked earlier about EO 12333 and FISA authorized, and there used to be an internet dragnet until 2011. It had legal problems because it's very hard to collect internet metadata without also collecting stuff that counts as content to telecoms. And so it was shut down from 2009 to 2010 and then came back online. And then in 2011, NSA was sort of like, we're not going to do it this way anymore. And there is reason to believe a significant chunk of that is now done overseas. And that's possible because the way the internet works, a lot of signals gets routed overseas. That's all available to the NSA. They can collect it there with almost none of the restrictions that the FISA court imposes. So they can use it for not just counterterrorism purposes. They can use it for counter narcotics. They can use it for just foreign intelligence purposes. And so that collection is not affected by USA Freedom Act. But what probably happens under USA Freedom Act is that if you think about it, nobody uses old style phones anymore, right? And there have been multiple reports of gaps in the NSA's collection because the metadata is limited to telephony data. There's been some indication they're not getting all cell phone data. That may have to do with 3G, 4G technology. They're probably not getting Skype data under that collection, which if they're not getting, the entire dragnet would have been useless to prevent the Boston Marathon attack because one of the brothers had no working phone leading up to the attack. And so there is very good reason to believe under USA Freedom Act, those additional kinds of phone data, which are not strictly speaking telephony data, will be collected in the much more limited call detail record program where NSA has to go to the providers to get specific 2 hops of communication. So that's actually a significant change that should make the dragnet more effective, but also means more innocent people will get sucked in.
Right, well, let's just take a step back a little bit. So based on the information that is currently available to the public, how effective has the Patriot Act been in addressing terrorism issues?
Well, part of the problem is the definition of effective. There have been arguments by members of the intelligence community as well as their friends in Congress who have said that, for example, Section 215 is crucial or essential, and there have in the past been claims that Section 215 actually prevented attacks, directly prevented attacks. That has been shown to be false. We have no direct evidence. As a matter of fact, a presidential commission almost 2 years ago now that took a look at the effectiveness of these the anti-terror or counterterrorism programs, including these intelligence programs, found that we don't have any evidence that these programs directly prevented a terrorist attack. Now, there are some indirect successes. For example, after the Boston Marathon terror attacks, Section 215 or bulk metadata collection was used, among other things, to verify that this was not part, or verify to the FBI's satisfaction that this was not part of a larger attack that was going on. Similarly, the attacks, I believe in 2013, on overseas U.S. embassies, they used the same methods to verify that this was not part of a larger attack that was going to move to the United States. That could be attributed to 215 as an indirect benefit. So that's difficult to prove. It's the question of the benefits start from absolutely essential at the very top, where we could not do our jobs without this, and that claim has been made. Down all the way down to, well, it's a nice to have. The problem that we're having is that every one of these programs so far have been claimed by the intelligence community as being absolutely essential, that we could not do our job without this. And what we've seen is that some of them have been outright falsehoods and or the least untruthful answers. And that has made Americans skeptical of these claims. It's a bit of crying wolf on the part of the intelligence community. And especially when we have presidential committees formed to to look at the question whether or not these are actually effective, and they come back with a somewhat negative answer, it makes the population even more skeptical, especially when we're talking about this balancing act. If for sake of argument, if we are to give up civil liberties in exchange for security, well, if these programs that we've given up our civil liberties for aren't actually providing any security, at least in not any direct, demonstrable way, then we start to wonder, well, this is kind of a bad bargain. And so when now that the dust is settling on this the Section 215 argument, some people had the impression that Section 215 was about to be repealed, and there were many of us, Marcy included, and had to tell people, no, calm down. Section 215 is huge. It was really just about the sunsetting of 3 provisions, 2 of which I don't think have ever been used.
One hasn't been used. The roving wiretap. So what hasn't been used is lone wolf.
Lone wolf, yes.
That's the kind of thing that FBI might redefine in secret, and there's reason to believe they did that. Roving wiretap, which if I keep changing phones, it says I'm going to wiretap Marcy Wheeler, and I can tap any new phone she adopts. That's how it's used, and it is actually used. I've seen a couple hundred times a year, but that's not an official from reports. But that was also used as a secret reinterpretation by the FISA court in 2007, rather than to target one person, Marcy Wheeler, for example. It targeted all of Al-Qaeda, and so that allowed the NSA to just wiretap whatever new account they believed was part of Al-Qaeda, which is an expansion and probably a not faithful interpretation of what the law says. Again, that's the problem with the FISA court. But I think it's Section 215 generally, and this is a point Jeff just made, but it's really worth reminding people, is the phone dragnet is just one part of Section 215. A recent DOJ IG report said that in its use through 2009, no FBI agent had been able to say it had broken a case. And that's all uses. That's the phone dragnet, which maybe about 2% was useful either for finding a terrorist or finding somebody who could become an informant or finding somebody who could be deported, which is how the FBI measured it. So 2% usefulness of the phone dragnet through basically 2006. But then there are these other uses. I talked about collecting purchase records for explosive precursors, other kinds of business records. What's interesting about this is Section 215 can be used both for counterterrorism and for espionage, which is broadly interpreted to include cybersecurity. And in 2009, the FBI kind of shifted and started doing a bunch of internet collection using Section 215. So what I just told you about the DOJ IG's finding through 2009, it may have changed. And given the kind of responses from FBI, I suspect it has changed. And I suspect that this used to get internet data, which they say they use for both cybersecurity and for terrorism purposes. I bet that's useful. And they say they have no other way of getting that data. So that's probably useful, but they won't tell us how. And other than that, I think the phone dragnet is useful primarily for finding informants, which they don't really want to talk about, but they use this very valuable metadata to find who's in the right place to inform on other people. And also, we know that they use this metadata, both the 215 and the 12333 metadata, to establish particularity for FISA Amendments Act. And this is something that came out of the Yahoo challenge. So in other words, they get by legal questions about other collection by saying, we've selected this person, we've proven this person is of interest to counterterrorism purposes or to some other kind of purposes by using this metadata to show their value. And so that's what the intelligence community is really talking about when they talk about its value, but they don't really want to explain all of that to you because it would, sources and methods.
Sure, that makes perfect sense. So I would assume the intelligence community would argue, as you've both explained, that these programs are used to target people, groups like Al-Qaeda, to target people who may be involved in terrorism operations or perhaps support. Not so much concerned with how much I binge watch Veep on my tablet, for example. So how...
That's true of the
Right.
telephone program. But again, what they're collecting overseas under 12333 is much broader, and they are collecting viewing. I mean, they're probably doing some of that with the 215 internet collection as well. But they are doing what kind of searches you're doing, what your internet cookies do. Uh, we know that they've collected porn watching habits, including off of U.S. persons. So they do collect that, but most of that falls under stuff collected overseas, although some of it probably comes from 702 as well. And the way in which they use all of these together does get to that kind of question. They may not look at you unless via the phone dragnet program they've discovered you're 2 degrees away from somebody of suspicion. But remember, that's a ton of people. Like if it were just the direct contacts of suspected terrorists, it'd be one thing, but they're doing it another hop out, so that's at least an order of magnitude more, right? And any of those people can be subject to, and it's in the phone dragnet orders. It's the phrase they use is the full analytical. I forget I love the term, but they basically say once you've hit that 2 degrees of separation, then you can be subjected to anything that the NSA has, which means then they may start looking into your porn watching habits or your, what kind of searches you do online. And that's when I think you start to see the privacy implications for completely innocent people who are just 2 degrees away from somebody of interest.
Right. So is it even possible, but how do we strike the proper balance between national security, civil liberties, and transparency so the public can be informed to a degree that satisfies both the public as well as the national security and intelligence communities?
Well, as Marcy pointed out, the USA Freedom Act is a good first step. I don't think it's the end of this battle in any way. And one thing we've been talking about this sort of in the background. When the intelligence community is making their arguments before Congress or before the American people, what we have found is their use of terms that we've been using today in a colloquial sense, collect, for example, they don't mean the same thing that we do when we say collect. So when they're saying we're not collecting everybody's data, they mean that they're not doing searches on these giant databases that have been built by collection in our sense of the term. So they are relying on a bit of a semantic difference, somewhat artificial semantic difference, I think some people would argue, about the meanings of these terms. And that goes to a larger question that we saw not just in the last 5 or 10 years, but also going back to the 70s in the Church Committee. Many of these issues may be able to be solved if the intelligence community was a bit more forthcoming about what they're trying to accomplish, what their goals are with these programs, and truly how effective they are. Part of the problem has been that every time one of these programs has been questioned, the first response, almost always, apart from silence, but once you get past the silence, the intelligence community comes out and says, these are absolutely essential. Well, if the programs are truly absolutely essential, there needs to be a better case, and this better case made before the American people. We don't need to see all the secrets necessarily. We understand that some of the secrecy is necessary, but there has to be a better transparency balance, because when you do have this curtain that's set up and you don't know what's going on behind the curtain, you're setting up a system that is very vulnerable to abuse, as we saw in the 50s, 60s, and 70s, and as we're seeing again today. I mean, it's interesting, actually. I think a very meaningful point that the Second Circuit, when in their decision on ACLU v. Clapper, actually brought up the Church Committee and said, look, we're heading to the exact same kind of situation that the Church Committee was dealing with. Now those laws, FISA is still on the books. It's been amended since then, but the principles are still the same. And we look at what the intelligence community is saying, we look at what the law says, and striking this balance, and we say, why do we keep on reinventing this wheel? And as Justice Sandra Day O'Connor said in a decision, that the time to consider whether or not to adjust the balance, with our constitutional civil liberties and the values behind them with national security is not during time of crisis. We have seen over and over that when we do make, frankly, rash decisions in times of crisis, we end up with things like the Espionage Act and the abuses that took place during World War I. Around that, we have the internment of Japanese Americans, and that we have Guantanamo, and we have these now again these intelligence abuses. So transparency is key, and the balance. We have always, as a nation, said that if you're going to tip the balance in any direction, it must be tipped towards civil liberties. And that's the bargain that we make. We're never going to have perfect security. That's just an impossibility. So, do we chase our tail, trying to achieve that perfect security? Or do we realize that, no, living in a country where we have strong civil liberties is more important than trying to chase this ethereal goal of perfect security? And that's where the conversation, there is no right answer to that question, of course, but it helps if we have an honest discussion and we get some of these ideas out in the sunlight for examination, and so we can make truly informed decisions.
Well, and I would add, I think there are three ways that we can radically improve transparency. And one is we need to improve the technical skills available to congressional overseers. And you do that partly by expanding the intelligence communities and making sure there are more technical people on it, but also by ensuring that more members of Congress can review things. Congressman Lieu and Hurd right now are kind of leading the charge against preventing encryption. They're both computer science graduates. And so, bipartisan, really aggressive opposition to the FBI's in turn opposition to encryption. But they are very rare members of Congress who know what they're talking about when they're talking about encryption. So I would say, the very limited control over these secrets by the intelligence committees is not working, and it needs to be broadened, especially in the House. Another area that really, really needs to be fixed is that the FBI is not asked to come up with the metrics to measure the impact of this. So the FBI doesn't have to count how many backdoor searches, how many searches, warrantless searches of content they get off of Americans' names. And there's a bunch of other things they don't collect either. And so when Congress says, we're sure there's no privacy problem, when Congress says under CISA, which is, of course, being debated today, we're sure there's not going to be any privacy problems, it is impossible for them to make those claims because right now FBI simply isn't collecting the data and providing the data to Congress to be able to do that. Another example is in USA Freedom Act, an improvement over the past version is for the first time the government has to tell Congress how they're using PRTT and which agencies. That's new, but it suggests that other agencies like DEA have been using it and not reporting it to Congress.
PRTT is what?
Pen register, probably location data collection. But they've, again, all of a sudden after years of this collection going on, this bill says, you got to tell us what it does. Another report that they're requiring anew is basically bulky collection under Section 215 has to be reported, and the kinds of minimization that didn't go to Congress before. So these metrics need to be in place for Congress to be able to do their job. And the FBI in particular is very hesitant to develop the metrics. And in a related issue is the FBI is hiding all this from defendants. So, for years the government said, well, 35 judges have found the phone dragnet constitutional. Only one defendant has even been able to begin to challenge the use of Section 215, and he's the only one they've actually caught. But every other defendant hasn't gotten notice on it. The defendants aren't getting notice on this pen register stuff, which is probably location data. Defendants aren't getting notice on EO 12333 collection. And unless defendants get notice, the people who have the standing to challenge this so that we can have that adversarial process of testing whether this stuff is constitutional, unless they get notice, then you really aren't testing. You really can't say that this stuff is illegal because it's mostly for the, largely hidden from judges still.
Mm-hmm. So that ties into my next question. For you, Marcy, what kinds of surveillance laws are in place now that aren't getting the attention or the scrutiny perhaps that they should in your view?
Right. To my mind, I'm grateful for Edward Snowden, but the focus on NSA has been misplaced because since 2008, the government has made a very conscientious effort to move FBI to the forefront of this process so that, for example, big chunks of Section 215 data get delivered in raw form to the FBI. And the FBI can access that data both as it comes in, but it rests in their databases for 30 years. And the FBI can access that data not just if they're conducting an investigation into somebody for terrorism, but at the assessment level. So, whether they have a tip without any real evidence of wrongdoing, whether they're looking for informants, whether they're trying to find, what the map of the Somali community in the Twin Cities looks like. For all of those purposes, they can go in and access this content and then kind of send it on into a black box with the FBI, and you'll never know. Defendants will never know that that's what elicited their criminal investigation. And that's true of 702 content. It's true of traditional FISA content. It's true of pen register. All of these techniques have been dumped into this black box at FBI, and they're affecting people's lives, and people aren't really being given the opportunity to challenge it or to even know about it. And as I said, one of the most interesting cases in recent years is a guy named Reyes Kadir Khan in the Portland area who was charged for, in conjunction with an associate, committing a suicide terrorist attack in Pakistan in 2009. And because of the timing of it, he clearly was, he would have, these illegal or questionably legal surveillance authorities would have been used against him. And his lawyer challenged them and said, we want a list of everything. And the government fought back. But the judge in that case was Michael Mosman, who's a FISA judge. And for almost the first time, he's like, we'll deal with this in SEPA. We'll deal with it as part of the secret process of what the government has to tell me, because he knew what's there. He's one of the 11 judges who knows what's really going on. And then within weeks after he made that decision, the government settled. And so it's a really interesting case where if the judges knew what they were looking at, they might demand a lot more accountability from the government, and the government might not press some of the same criminal cases that really are based in illegal or questionably legal methods.
And SEPA is?
What is it? Classified Information Protection Act, which is just the means by which the government can use classified information in criminal trials and substitute information such that the defendant can still challenge it or use it, but the classified information won't be disclosed either to the defendant or in court.
Great. Any reaction to that, Jeff?
I think the issue of transparency is the elephant in the room here. I think that when we're talking about the effectiveness or non-effectiveness of any of these laws and how they're actually being applied, really does benefit from a little bit of sunshine, as we saw in the case that Marcy just mentioned, and there are a couple others that, when pushed, the government has chosen to settle. And two things that are happening here. One, it's an interesting fact, however you feel about the guy, we would probably not be having this conversation were it not for the revelations of Ed Snowden. That's unfortunate for a lot of reasons, but mainly is some of these things are clearly relevant to us as American citizens and others. And the fact that the only way that it could ever get out was through arguably illegal means is troubling. The other part is is that when we talk about surveillance, I think we tend to think of, especially in the post-Snowden era, we tend to think of NSA, FBI, CIA, basically tech surveillance. We're talking about, it's email, cell phone, that sort of thing. When surveillance is really a much bigger issue. And it's all the way from super high-tech surveillance to no-tech surveillance. And that's the police just patrolling, for example. And surveillance by itself it's a value-free term. It's not a good or a bad thing, it's just a thing. And versions of surveillance are necessary, as we found, for a working society. And the question is, well, how much of that are we willing to deal with? As we become more used to these programs, the fact that you yourself or I have nothing to hide, this is the nothing to hide argument that you hear all the time, is not relevant, because I cannot speak for everyone in this country. And what nothing to hide means depends on what they're looking for, they being whoever's doing the surveilling. So as we saw in the abuses of the 50s, 60s, and 70s, Martin Luther King probably had, in our eyes, nothing to hide. He had an extramarital affair. He was illegally recorded during that. The FBI infamously and anonymously sent him a note that said, "You should really kill yourself, Dr. King, because we have this information." These are clearly abuses, and if we little by little, like the proverbial boiling frog, if we start to allow these abuses and hide them as like, well, I personally have nothing to lose here, we as a society start to lose out, because we are seeing and have seen for many years this encroaching effect of a greater surveillance society growing in the U.S. and other countries. Prime Minister Cameron famously said recently that for too long British citizens have gone along without not being surveilled with the assumption that they're just because they're law-abiding citizens. The implication there is like, well, law-abiding citizen is no longer a barrier to surveillance. It's a dangerous road to go down, and this halo effect. The reason why there are many of us in the community that push back and question these programs is because we don't want to necessarily go down that road. We have a strong constitutional incentive to avoid these sorts of regimes, and this is why we question these things, and this is why transparency is so vital to this process.
Right. So let's take this down to sort of an everyday level. In terms of thinking about these issues, what should the average person with a smartphone or tablet or just connected to the internet be thinking about in terms of how the technologies they use every day intersect with these legal issues?
Well, for your average person, they're more likely to be targeted by criminals than they are by NSA, but even there, some of the same methods are useful. So in other words, strong passwords, use encryption while you can. One of the problems with the FBI's campaign against encrypting phones is that there's something like 1.1, I don't know the exact number, but there are a huge number of smartphones stolen every year. And if your phone is encrypted, then people who are trying to use the phone to steal your data, to steal your identity, aren't going to be able to use it. The same also happens to be true if the NSA is trying to spy on you because you're a Muslim cleric. But I think there is a notion of hygiene that applies to both whether you're going to lose your identity because you shopped at TJ Maxx or whether the NSA is going to come after you. But I also think that just as a comparison, there was this report of a really devastating hack of the Office of Personnel Management last week, which hit somewhere between 2 and 4 million government workers and got very, very personal data off of those government workers, and it's going to expose them to spying going forward. Well, that's the same kind of bulk data that the NSA collects overseas, and the NSA does not limit itself to government employees. We know that they go after tech employees. We know they go after tech company executives and search for proliferators, and so that's the mindset. If if OPM's hack is bad, and it is, then we as a society need to really consider what is a legitimate target for government hacking, uh, for what kind of data should be kept, whether it is target or the government, because that data is going to be vulnerable out there, and you can be compromised in any number of ways.
Anything to add to that, Jeff?
Another example of this issue is the FBI's, and Marcy alluded to it, the FBI's recent call for encryption backdoors or security backdoors. It was the conversation was started last winter when Apple and Google both announced that they were going to encrypt their customers' communications, certain customers' communications, in such a way that not even Apple or Google could get at it. It was between the sender and the receiver, and that encryption could not be, there was no way that they could reverse that process. The FBI director, Comey, and others came out against that policy and say, no, we should not have a no-go zone where where law enforcement couldn't go even if we had a legal right to go. The problem with that argument is that from a purely technical point of view, we don't know of any good way to do to create this back door or front door or whatever it is you want to call it. We don't have a way of doing that. We have, back in the early 90s, mid 90s, we had what we laughingly refer to as the first crypto wars, where the government was talking about creating a key escrow system where whenever you wanted to use strong encryption, there would be, you would create two keys. One, it's a little more complicated than that, but basically the government would have a master key that they would put in escrow, and that if they got a warrant and that sort of thing, they would be able to unlock the encryption. It doesn't work. A professor here at University of Pennsylvania, Matt Blaze, famously discovered a flaw in this encryption scheme, or decryption scheme as it was. And now we're having that same conversation again, and it's just, it's complicated, it's beyond the scope of this conversation, but many people in this field, in the technical people, engineers, computer scientists, have gone before Congress and said that is a bad idea, yet we're still having the conversation. The FBI has not backed off from that request. And this is a very real concern, because it's with the FBI, the NSA, they have both a defensive and an offensive side of the house. So, for example, the NSA has an offensive side where they're doing hacking of targets that they're interested in getting that data. They break into systems and that sort of thing. But they also have a defensive role, a defensive mission, which is defending the cyber security. There, I said cyber. But the cybersecurity defense is one of their missions. So you have these conflicting missions, and if we do something, let's just say that there was some system set up where backdoors were created, it's almost certainly going to weaken, well, not almost certainly, it will weaken our defenses, not just of power grids and that sort of thing that we're working out, but the same thing that we're worried about that Marcy was talking about with respect to criminality. Our personal financial data, our personal data can be grabbed. And as we found, when you have a patient, well-funded adversary, what used to be referred to as an advanced persistent threat, oftentimes they're affiliated with the government, but not necessarily. They're not just after the quick smash and grab. They don't just want your credit card number. They're going to patiently gather all kinds of different kinds of data, so that with the IRS breach that we saw recently, they can actually combine data to get past the IRS's rather weak security mechanism to get to file taxes on your behalf and get refunds back illegally. And so many people were finding this past tax year that the IRS acknowledged, hey, we got your tax return, and they said, I haven't filed my taxes yet. And we're talking about tens of millions, actually I think the number is over $100 million worth of fraudulent tax refunds that were sent out using this rather ingenious, or somewhat ingenious, but a very patient scheme. And again, to Marcy's point, we have to decide what legitimate targets are, because this is that sort of scheme is exactly what the NSA is doing also on the offensive side of the house.
Right.
So these are important questions that we have to decide as a nation.
Right. And related to that, Marcy, you're very well known for going through just troves and troves of data, these so-called document dumps by governments and other agencies. So first question, so what kind of information are you seeing as part of that? And how can the wider public be better informed, keeping in mind most people don't do what you do in terms of getting at these data troves?
Most people have a better life than me, huh? You know the Office of Director of National Intelligence, so James Clapper's office, I think adopted a very deliberate strategy after the Snowden leaks to flood people with transparency. And they have released a ton of information about all of the phone dragnet orders, for example, are available. And there are very subtle aspects about changes in that program which are available. You know that Verizon changed their delivery in 2007. You know that there's a new emergency provision. You know that they probably abused that already. You can see trends in data. So when the FBI started using Section 215 to get internet data, the numbers exploded. I mean, they're still relatively small. It's like 200 orders, but those orders could be hundreds of thousands of people. And so those are when questions should be asked. We also know that the FISA court started imposing minimization procedures on those orders, and that's the kind of stuff that's out there. I don't actually think the privacy community has done a very good job of using that transparency, and there's a lot of stuff. I mean, I know this stuff pretty well, but there was a part of USA Freedom Act which I should have realized was going to authorize the use of data that probably was collected illegally, and I just forgot. You know, so that data's out there. And maybe it'll stop under a new president. Maybe it won't. But what you have to do, I think, with that knowledge is then to be able to come up with an understanding of and user impact. As I say, you know, it always comes back to the FBI because they're the ones who can put you in jail, and that picture still isn't there yet either. For your average person, you shouldn't be working at that level of data, but you should be asking the kinds of questions of your member of Congress. You know, how does the NSA dragnet connect to the people who can put me in jail, the FBI? I guarantee you 300 members of Congress could not answer that, probably more than that. And if they can't answer that, then you should insist that they try and get that information, because if you know, our advocate, our representative for being able to exercise some kind of democratic control over this are our members of Congress, and they just don't know enough about it. And to some degree, they're not allowed to know enough about it. But until they start asking those questions, then, you know, the NSA and the FBI and the CIA will continue to operate in the dark without much accountability because no one's asking the right questions.
Jeff?
Marcy sells herself short here. No serious student of surveillance law, I think, does not follow Marcy at her blog. You know, not just fans, but detractors. She gets into some rather interesting fights with people across the spectrum. But that said, there are a number of sites like hers which are probably at a deeper level than most people would be interested in. But one thing I've noticed is that over the past decade or so, newspapers like the Washington Post and the New York Times have actually done a very good job of expanding their national security desks and doing really true investigative journalism into these issues. And as we saw with the Guardian and the Washington Post and the New York Times, to some extent, you know, they have been rewarded with Pulitzers and other awards. Mm-hmm. So I commend some, not all, but some of these newspapers were really taking this issue seriously and trying to get at what some of the core issues are, get past some of the technical weeds and the legality or the legalism, and get to the true core issues of what we as citizens should be concerned about.
Right. So, Marcy, you talked a little bit about elected officials. Jeff, you talked about some of the better coverage you've seen in the media. So, whatever position a person has who's a U.S. citizen on these issues, how can they make their voice heard? Is it through contacting their member of Congress? Is it through reading up more? Is it through participating in town halls? How do you make your voice heard to people?
Well, I think right now the conversation is at the national level, so we're really talking about member of Congress, your representative or senator, and unfortunately mileage varies with respect to the member of Congress. I mean, we have some members of Congress with technical degrees that really understand this and can put this in terms that everybody can understand, do that translation. And then we have others, who I won't name, but don't even use email. I mean, you know, their staff is using email, but they famously say, well, I don't touch the stuff. That's problematic. I mean, we live in a highly technological society. I think members of Congress are not doing us any services by not at least attempting to understand these issues. And by forcing, or at least pushing members of Congress in this area, however you feel about it, oversight is important. And we have seen a kind of a hodgepodge approach to oversight. Much of it in the early days was relatively bad, almost no oversight. Now we're seeing a little bit more of it. But it really depends on members of Congress that understand these issues. They don't necessarily have to be computer scientists like some of them are, but to make an effort and just say, well, I don't do email, that's not acceptable anymore in today's day and age. So I think that pushing your member of Congress, questioning them, and getting those answers, the satisfactory answers, however you come down on wherever you are on the political spectrum, I think we deserve some of these answers.
Right.
I would add, though, that I don't give up on local involvement. There's been a real effort in the last couple of years to bring transparency to stingray use, which is a kind of technology that allows the user, which may or may not just be the government, to pretend to be a cell phone tower and with it collect a lot of data about your phone and everyone else nearby you. And at both the national level, things like the ACLU trying to FOIA the ways in which local police departments are using them, but also at the local level where people are going in and saying, we need to know exactly how the police is using it, how much they're using it. It's brought a lot of transparency to the issue. And one of the things that's come out of that is not just that some police departments are not getting any legal process for these stingrays and some are, but also that the judges have not been told what they're approving. And so you really need to have this kind of level of transparency for the magistrate judges who are the ones approving these to really understand what these new technologies entail.
Right. Well, Marcy, Jeff, this has been a really illuminating, eye-opening discussion with some really compelling recommendations and analyses. So I want to thank you both for joining us today. It's a great discussion, and I want to thank everyone for joining us here at Case in Point.